What if I told you that in the eyes of the law, a crime can actually be committed before a single physical law is even broken? It sounds strange, right? Well, today we're going to explore the hidden life cycle of a crime in India. It's a journey that starts not with an action, but with an idea. From a secret plan to a public trial, let's trace the path together.
So, let's start with that really fundamental question. When does a crime truly begin? Is it the moment a weapon is bought, or maybe when a lock is picked? Or could it be much, much earlier than any of that? The legal answer, you'll find, is often not what you'd expect. And here it is. It might sound a little surprising, but the law can step in the very moment a plan is hatched. Long before any action is ever taken, a crime can already exist. All it takes is a simple, or sometimes not so simple, agreement. And this brings us to the very first stage in our life cycle, the crime before the act.
What we're talking about here is criminal conspiracy. This is where the law targets the very foundation of organized crime, the planning stage itself. It's a really powerful tool for law enforcement because it allows them to potentially stop a crime before it ever has a chance to happen.
Now, the definition of criminal conspiracy in the Indian Penal Code looks deceptively simple. Section 120A is what defines the act, and then 120B is what lays out the punishment. But the core idea is this. A group of people planning to do something illegal is a threat to society all by itself, even if their plan never ever gets off the ground.
So, to prove a conspiracy, a prosecutor has to establish 3 key things. First, there has to be an agreement. And we're not talking about a formal written contract, just a mutual understanding. Second, the goal of that agreement has to be illegal. And third, there has to be a genuine meeting of minds, meaning everyone involved is on the same page about the criminal objective. And here is the absolute crucial part. The agreement is the offense.
Okay, but how on earth do you prove a secret agreement? I mean, people planning a crime don't usually keep meeting minutes, right? This is why courts almost always have to rely on what's called circumstantial evidence. Things like a chain of phone calls, a series of meetings, different actions that, when you link them all together, point to a common plan. But the judiciary is also super clear on this. A strong hunch or a mere suspicion is not enough. You need a solid, unbroken chain of evidence.
Now, it's really easy to get conspiracy confused with a similar legal concept, abetment. So let's clear this up. The key difference is this. Conspiracy is all about the planning. The crime is the agreement. Abetment, on the other hand, is about actively helping or instigating a crime that actually happens. You can have a conspiracy that fails completely, but abetment is always tied to an act that was actually committed.
And this very principle was driven home in the landmark Kehar Singh case. The Supreme Court basically said, look, you don't need a recorded conversation of people explicitly saying, let's commit this crime. A court can look at the conduct of all the accused people and infer that an agreement must have existed for them to act in such a coordinated way.
That whole idea of figuring out a plan by looking at people's actions brings us perfectly to our next stop. If the conspiracy is the secret plan, how does the law make the actions of the accused visible to a court? Well, this is where Section 8 of the Evidence Act comes into play.
Think of Section 8 as a powerful legal tool that basically turns human behavior into evidence. It lets the court look at the why, the motive, the how, the preparation, and of course what a person actually did before, during, or after the incident. It helps paint a complete picture that goes way beyond just the final act itself.
You see, conduct isn't just one thing, it's a whole timeline. Courts can look at what happened before an incident, like somebody buying materials or scouting a location. They obviously look at actions during the event, and crucially, they examine what happened after. Did the person run away? Did they try to hide evidence? These actions that happen later can be very, very telling.
But, and this is a big but, there are really important safeguards to prevent this from being misused. The courts are very careful. For instance, just because someone ran away from the scene doesn't automatically prove they're guilty. There could be other reasons for panic. Like the court said in the Sanjay Takran case, absconding is a factor, sure, but it's not the final word. And this section is about specific conduct related to the crime, not just a person's general character.
Okay, so we have a plan, and we have a way for the law to try and prove that plan through conduct. But this whole legal process can take years. So what happens to the person who's been accused in the meantime? This brings us to a critical balancing act in the justice system, the whole question of bail.
This incredibly powerful line from Justice Krishna Iyer really captures the entire philosophy of bail in India. The default position, the starting point, is to protect a person's liberty. It's all based on that fundamental principle that you are innocent till proven guilty. And this is so important in a country with a huge number of under-trial prisoners, to make sure the process itself doesn't become the punishment.
The system for seeking bail is kind of structured like a ladder. An accused person usually starts at the bottom rung, at the magistrate's court, under Section 437. If bail is denied there, especially in more serious cases, they can climb the ladder to a higher court, the Sessions Court or the High Court, under Section 439. And these higher courts have much broader, more discretionary powers to grant bail.
So how does a judge decide? Well, it's not random. They have a specific set of factors to weigh. They look at how serious the crime is. They consider the strength of the initial evidence, what's called the prima facie case, and then they have to assess the risk. Is this person likely to disappear? Are they going to threaten witnesses or tamper with evidence? It's a really careful calculation, trying to balance individual freedom against the integrity of the trial itself.
All right, so we've looked at the plan, the proof, and the procedure. Now let's put all these pieces together and see how they play out in a real courtroom battle. This is like looking at the strategic playbook for both the prosecution and the defense.
You can really see the strategic tug-of-war here. The prosecution's job is to connect all the dots. They use the person's conduct under Section 8 to build a compelling story of a conspiracy under Section 120B. Then they argue how serious that story is to deny bail. The defense's job is to break those connections, to create doubt. They offer innocent explanations for the conduct and argue their client has roots in the community, isn't a flight risk, and deserves to be granted bail.
So, from a hidden agreement to a public argument over liberty, we've basically traced the entire life cycle of how the law handles crime. It's a journey defined by this constant, delicate balance. The need to punish criminal plans versus the duty to protect individual freedoms until guilt is proven beyond a reasonable doubt.
And that leaves us with one final thought. In this really complex life cycle, from the secret plan to the circumstantial proof to the procedural fight for bail, at what stage do you think justice is at its most vulnerable? Is it in incorrectly identifying a true conspiracy? Is it in fairly interpreting a person's conduct? Or is it in wisely deciding who gets to walk free while they await their trial? The answer to that really defines the character of a justice system.